HOA.
Good morning. It's so exciting to see everybody come and participate in this important symposium. I want to welcome everybody to Missouri City. Councilmember Clouser, Councilmember Emery, and I, and Jeffrey Boney will be here shortly. We all are very interested in hearing what Rice and Rice have to say. With that, I'd like to also thank Rice and Rice for coming out today. Their excellence in HOA knowledge and representation within HOAs is bar none. So we welcome them and we look forward to hearing what they have to say.
Thank you. You don't have to say it.
Okay. Thanks, guys. Come on in, Floyd.
If he would have been brief like he said he was, okay, I wouldn't have said anything. But thanks again for being here. Just shows the interest that our neighbors and our citizens have in our HOAs. And of course, our HOAs are here also to get some input. So with that, thank you and enjoy the rest of the day and hope you get a lot of information. Thank you.
Thank you, guys. Come on, Lee.
Listen, you see what happens when you give politicians a microphone. I was trying not to, but anyway, Councilwoman Lynn Clouser at large, position 2. Thank you all so much for spending your time here with us. And I want to thank these wonderful attorneys. And I also want to thank your Planning and Zoning Commissioner, Sonia Brown Marshall, for being here. She's such a leader in the community. And so thank you for having this. Feel free, I have my business cards. Mayor Pro Tem Maroulis has his business card. The mayor can't be here. He was burying his mother. So we bring greetings on behalf of him. And thank you so much again for being here.
All right. Okay. All right, guys, thank you. We're not going to hold you up any longer. I'm going to bring forward now, I call them the dynamic duo, Batman and Robin. I mean, they are just that good. They reign from Bernie, Texas. They have offices in Fort Worth, Austin, Houston, and Dallas. And they might have one more. But I'm going to move me out of the way. Mr. Garrett Rice, come on up. Y'all enjoy.
Good morning, everyone. How's everyone doing? First and foremost, I would like to welcome everyone to the HOA seminar regarding the legislative changes that were made to chapters 202, 207, and 209 of the Texas Property Code. My name is Garrett Rice. I'm an attorney at the law firm of Rice and Rice. I would also like to thank everyone for taking the time out of their Saturday morning to come attend this seminar. It will be extremely informative, so I promise it won't be a waste of your time. I would like to thank Ms. Sonia Brown with Marshall Management for getting the word out about this, and she is truly an expert in property management, and we can't thank her enough for all that she does with our firm. And I would like to thank Ms. Kelly Matt for helping get the word out about the seminar as well, and putting the building out for us, and thanking Missouri City for everything that they did, and the council members for their attendance. Thank you for showing. First and foremost, I want to say that this is an open forum seminar. So if there is a topic that we touch on or a section within the outline that you guys are going to follow with us, please don't hesitate to raise your hand and ask a question. We'll stop, we'll address it, and then we'll keep moving forward. Even if it's not in the packet, don't hesitate to ask. We'll also address that question as well. We have a lot of ground to cover today, so I'm going to turn the floor over to the founding partner of the firm. She co-authored 204 of the Property Code and sections of 209, and truly is a wealth of knowledge. Ms. Susie Rice.
Thank you. All right, thank y'all so much. I'm going to take this off. I feel more comfortable just holding these microphones. All right, y'all ready to get started? Okay, pull out your packet where it says at the top, 2021 amendments to the Texas Property Code, and let's jump in the water and go. All right, is everybody ready? Okay, 202.006 is the first change, and as we go through this, please stop me, ask questions, because you're going to have some questions when we get into actually what they've done. Well, essentially, 202.006, that's dealing with public records, and all of your dedicatory instruments have to be filed in the property code. And when I'm talking about dedicatory instruments, I'm not only talking about the articles of incorporation, your bylaws, your declarations, and any amendments, but let's get rules and regulations on file, any pool rules you may have, any tennis rules, any parking rules. Everything needs to be on file in the property records. Otherwise, we're going to have a hard time enforcing them because the property code also says if they're not on file, you're not going to enforce them. And people will use that against us in a lawsuit. I've seen it happen before. Make sure everything's on file. What the legislature added this time, as we go through this, everything in red is new. Everything in black has already been there. Everything in red is what's new. If it's highlighted in yellow, it's a whole new section to the property code. All right, so keep that in mind as we go. Also, everything goes into effect September 1, about a month away. Unless I tell you it doesn't, there's only one thing that does not go into effect on September 1, and it's dealing with filing your management certificates with the Texas Real Estate Commission. That will go into effect December 1, 2021. So they've given them a little time in order to create the website, but I'll get into that with you when we get to that section. So keep in mind, all of this other, September 1, 2021, these laws go into effect. What Section C says in 202.006 is, if you do not have your dedicatory instrument on file that says people have to pay assessments, you're not going to collect those assessments. So let's say you live in a subdivision where you originally did not have regular assessments, but you've amended your deed restrictions to create a regular assessment. Make sure that is on file. Otherwise, you cannot collect those assessments. Most of us don't have to worry about it because the developers did that when they created the original documents, but there are a few old associations where that is applicable to them. All right, 202.018. This, y'all, is a bombshell to associations. In the past, what we had is people could put a religious item on their door frame, had to be only 25 inches in height and width. Now, people can put any religious item in their front yard, no restrictions on height or size, as long as they're within the setback lines. Think about that. And think about how many religions we have in America and how crazy some of them are. And what kind of symbols they can put out there. So if somebody, let's say somebody says, hey, ACC, I'm going to put up a 30-foot cross. Or I'm going to put up a 30-foot evil eye because I'm a Satan worshiper. This allows it. The only thing that we have, the only little bit of power we have, nothing can jeopardize the public health or safety, and it cannot violate other type of laws. Let's say somebody wants to put up something that is going to infringe on the civil rights or be extremely offensive to another group of people. We then could possibly go after it that way, but it's going to take litigation to do that. They also can't attach it to, say, a light pole or a street sign that may be on their property. They can't attach anything to that, but there is no limit on height and size. And so when I read this, I'm like, oh my goodness. We saw how crazy the last election cycle was and what people did and the things they put up and everything else. This gets into the wrong hands. It's devastating to our neighborhoods. So we're already getting with members of the legislature to clean this up. And I think a lot of this came from the last election cycle, and also COVID, because it became a big deal when people could not meet. They quit having church services for a while, and people felt like we were stepping on their religious freedom. So I think some of this came out of that fear from the pandemic and also from the election cycle. So we are going to work to clean this up. We're going to have symposiums later on and in the first of next year to meet with y'all, find out what's going on so we can pass information on to members of the legislature. So don't be surprised when something pops up in your yard. Now, people can't go and just make up a religion and say, I have this here because, I'm of the church of Donald Trump. That's not going to fly. It's got to, we can at least fight them from that standpoint as, no, you've got to show me, where is it an established religion? And is it recognized by the IRS as an established religion? And is it treated from a tax standpoint that way? And do you have services? And so we can get into that. We've got little ways to try to stop it, but they've opened the door with this. And just imagine what people are going to do. Go to page 2. The next change is they came up with swimming pool enclosures. And this is brand new. They've never before had anything in the property code dealing with swimming pool enclosures. You usually have that on a local level in cities, and some counties will have statutes that deal with swimming pool enclosures. So essentially they say an enclosure is a swimming pool or spa, and they can basically put an enclosure up that is transparent mesh or that clear type fencing. It can't be more than 6 feet tall, and you can't climb it. So I went and looked up, I Googled transparent mesh, because I wasn't sure what they're talking about. The transparent mesh that comes up, you can climb it. I mean, it's fencing with squares in it, and I could climb it, a kid could climb it, so it is climbable. Now, what they go on to say is, we cannot, as property owners, as an association, stop an owner from installing black transparent mesh fence. They have the right to install. Now you can tell them you can't install a blue one, or you can't install a red one or a pink one, but essentially the legislature says they have the right to install a black transparent mesh metal frame fence around their swimming pool. So, you know, a lot of y'all already have fencing around your yards and everything. Other communities say if it's a golf course community, if they don't allow fencing on the golf course, then those people can come and say, yeah, I want to put this black transparent mesh fence around my yard, and you can't stop me. And we won't be able to. Why they chose that, I don't know. I don't know if they're in the fencing business, somebody in the legislature, or if their brother-in-law is, or what. I don't know what their hang-up is on this type of fencing. This is something we need to clean up too, with regard to the type of fencing. My attitude is let's deal with the fencing that's based on the deed restrictions, because each neighborhood is different. Each one is. So we don't need to just do a blanket, we allow this type of fencing, because look at all the difference we have in neighborhoods. Some are townhome communities, some are single family that are on smaller lots, some are on acres, 2 acres, 3 acres. So we are going to work on cleaning this up too with regard to the fencing. The next change they got into was security measures, and this is another one, 202.023, where we've got some problems to deal with. Now, this does not apply to condominiums, and it doesn't apply to a master mixed-use property. That would be a 6,000-acre subdivision with hotels in it, businesses, and also homes. So those are few and far between. Now, they said we have to allow these security measures, but they said also these are including but not limited to. For one thing, we have to allow security cameras. And with regard to the camera, what we need to do is we need to pass a resolution with regard to cameras and say, if you have a security camera, you can't point it at your neighbor if you're ticked off at them. You can't use it to harass your neighbor. Also, with regard to motion detectors, a lot of motion detectors, you have the lights come on with the motion detector. We need to pass resolutions as HOAs and say, if you have those motion detector lights on the side of your homes, which are fine, but they shine into the neighbor's bedroom and it looks like noon in their bedroom when it's midnight, we've got to make them at least blacken out that light so it doesn't harm their neighbor from being able to get some sleep or anything else. So we can come up with measures like that because we're not stopping them from having their motion detectors, but keep the lights in your yard. Don't have them disturbing your neighbors and lighting up their house every time something sets off that motion detector. The next one is a perimeter fence. So I looked up the definition, which is what we would do if we were dealing with a court case. What's a perimeter fence? Perimeter fence is the boundaries of the property, y'all. That's front yard. That's front yard fencing. So in addition to having your humongous religious item, we've got front yard fencing now. Yeah. Absolutely. Yes, sir.
Because this is a big issue within communities that have lake property and things like that. From a lawyer's perspective, security fencing is different than other type of fencing. Usually it has a height requirement. It can't be climbed and things like that. Because this is under this part of the statute that it is under security and not just regular perimeter fencing, is there a way an HOA can kind of make sure that there's a specific kind of fencing that is acceptable or not acceptable?
Well, here's if you go down and look at under section C, it allows us to regulate the type of fencing you may install. However, you run into this problem. The judge is going to, let's say that we come up with a resolution and we say, you can't have, fencing that looks like something that was surrounded Osama bin Laden's house. That high, looks like stucco type concrete fencing, or you can't have a 6-foot high fence. And what the judge is going to do is the judge is going to look at what do your restrictions allow with regard to fencing. So that's what they're going to be saying, because you would be enforcing that restriction against them with regard to what they put up behind the house before this came along. So we've got to be careful and not go beyond what our restrictions allow us to allow or prohibit. Plus, the legislature did not limit this. They just said perimeter fence. They didn't go into a lot of detail. There's not much that a judge can look at with regard to, he may say, well, it's under security measures, but where does it say perimeter fencing that fits security type issues? So the title, he's not going to take much from the title unless the legislature tells him to take it from the title. He's not going to read anything into that statute that's not there, but what he is going to look at is you being able to regulate the type of fencing. What type of fencing are you allowed in your governing documents? So we're going to have to be able to say, why wouldn't they be able to have it in their front yard? And our argument's pretty weak, because it says in the deed restrictions they can have it, that type of fencing. So how are we going to stop them from putting that in their front yard? Unless the legislature, that's why we've got to go back and clean this up. They weren't thinking when they did this. They weren't thinking at all. I don't know why they would want to live next to somebody who has a 6-foot high wooden fence all around their property. Who wants to live next to that? Because when you drive into that neighborhood, what do you start thinking? Y'all must have a high crime rate here. It's your curb appeal. Yes, ma'am.
Okay, just so that I understand. So in his case, if their restrictions require wrought iron in their rear yard, and the person puts the same on the front all the way around,
Right.
because their restrictions states what type of fence it should be, then that.
Yes, because it says we can regulate the type of fencing, but our regulations basically come from their deed restrictions. Okay, so we can't go above and beyond and try to add new regulations into our restrictions that are not written there.
Okay, so if our restrictions say you can have a 6-foot wooden fence in the back,
Right.
that automatically
It would be hard to argue. You've got to think about, okay, if I had to argue to a judge, we allow 6-foot wooden fence in the back. So how am I going to argue to him, you can't have it in the front, when the legislature said that they can have a perimeter fence and we can regulate the type of fencing, but where does our power come from? Our power to regulate comes from our governing documents. So we are limited to regulating the type of fencing based on the governing documents. Did you have your hand raised, sir?
Yeah, I was gonna ask on, you were talking about how the deed restrictions may already have fencing, outlined. Well, like in my neighborhood, we have waterfront lots in the backyard.
Yes, sir.
We have lots that are on the perimeter of the neighborhood that do not have water. So on, like my house, I have a wooden fence in my backyard that's 6.5 foot tall. I don't have a waterfront lot, but it tells me what I have to do for that fence. So according to this new statute, I can put a wooden fence up all the way around my house.
Yes, sir.
But in our neighborhood with the water lots, the deed restrictions state in their backyard, they have to have a metal fence. So does that mean they have to put a metal fence?
Yes, sir. That's what I would argue.
And no wood?
That's what I would argue, yes. Because you have the right to regulate the type of fencing. They said you can regulate the type of fencing, so our regulations come from your particular restrictions. Yes, sir.
Okay, then I just want to take it further because we're talking about perimeter, right? So that's a property line around your property.
Yes.
So that means that this also includes traversing your driveway.
Yes, sir.
Is that what it also includes? So then you have to have some kind of, something put in your HO, if you don't have something with regards to a gate on your driveway, whether it's automated or not automated or whatever, an HOA would now have to create under the ACC something to address fencing on the driveway as well.
It's going to, yes, because it's for security measures, so yes, they're going to have
So,
some type of gate there.
Someone cannot put it around their driveway, right? They have to now traverse their driveway, otherwise that would not be considered perimeter fencing because you're removing it. I'm just trying to understand.
Well, most likely they're going to add in there, when they submit it for approval, they're going to have some type of gates over their driveway so they can get in and out because it's for security. They don't want to leave it open, but they're going to present it with some type of gate, electronic or just manual. Yes, sir.
You got all your declaration of instruments filed for your HOA? Does the state override your bylaws?
Yes, sir. Yes, sir. This is going to trump you right here, because they're basically saying, you can't do this. You can't stop a perimeter fence no matter what your documents say. They're essentially telling us. They're like our parent, and they just came in and laid down the new rules for us. All right, so we've got a lot of work to do with the legislature, don't we, ladies and gentlemen? Yes, I don't know where they live, but they're not in our neighborhoods. So, maybe they want that perimeter fence around theirs. Okay, 207.001. Essentially, since 1995, since I've been dealing with the legislature, they have been tinkering with management companies. And so they have now jumped in the water and they are defining what is a management company, and they're even putting some boundaries on them. So essentially 207.001 gives the definition of it says basically management company is included in the definition, and we'll go down when we get to 209.002 and basically show you what that definition is. But 207.003, does everybody know essentially what a resale certificate is? What happens is when somebody is going to sell their home, the buyer or the title company or either the seller of the home can say to the association, we want a resale certificate, and they have a timeline, 10 business days, to provide that information regarding the association, the dedicatory instruments, how much the assessments are, if there's violations, if there's lawsuits that the association's involved in. So What the legislature has come down and they've said, when the association provides that information, they can only charge $375 to assemble, copy, and deliver the information. They can't charge any more than that, only this amount. And if you needed an updated resale certificate, then you can only charge $75 for the updated resale certificate. So they've put a cap essentially on what everybody can charge to assemble, copy, and deliver that information. Now, 207.004, which is right below that, deals with the resale certificate and the, do you have a question, ma'am?
I'm sorry, I need to go back.
Okay.
You talk about the perimeter of the fence.
Yes, ma'am. You're so stunned by that, you gotta go back to it?
When you talk about that, did you have a neighbor that may want his fence to come all the way out? What about the neighbor that's next to him that does not want that? How do you argue that?
The neighbor who wants it is gonna get it. He's gonna get that fence. He's gonna put it up. I mean, if you were, let's say somebody came to you, your neighbor, and said, hey, I'm gonna put up a perimeter fence all the way around my
But it's
property.
on the property line.
Yes, yes. And they didn't think through that. You may not want it, you may think that, no, that's horrible. But don't contribute, but at this point in time, we can't stop them.
You can't do have a resolution or anything, you know, your own architectural committee or something, you can't stop them.
We can't stop the perimeter fences at this point in time, no. Does somebody have a question back there? Okay. Yeah. I mean, really all you can do is say, I'm not going to contribute money to it because I don't want it. But it's not, but they can put it up. I mean, they can submit it to the ACC and they have the right to put that up. Yeah. Okay, with regard to, yes, ma'am.
But that comment, you said it could submit to the ACC, but can the ACC deny, because this is a state law now, can the ACC?
No, ma'am.
Okay.
No, ma'am. All the ACC can do is say, let's say they want to put up a wooden fence, and like that gentleman said, on their waterfront lots, it only has wrought iron. Well, they couldn't put up a fence, wooden, but they could put up the wrought iron because it's allowed by their governing documents. So all we can do is regulate the type of fencing based on what's in our governing documents. All righty. 207.004, this basically is, they've got deadlines to get the resale certificate to you. Like I said before, it's 10 business days. And make sure when you're reading statutes, pay attention to when they say business days or 10 days. A business day is Monday through Friday, don't count Saturday and Sunday in those days. So it's very important when they put in whether it's just a day or a business day, because that determines when it makes a big difference on when something is due. And essentially they've come down and said, if they have to make a second request and you haven't responded to their first request, you've got then 5 business days to get that to them with regard to the second request. If you fail to respond to any of their requests for a resale certificate, the legislature has said that they can file suit against you and get a $5,000 judgment against the association for your failure to respond. Now, most of y'all, if you're represented by a management company, they respond. But I ran into a few situations in the last couple of years where we had board members who weren't responding to anybody. People were trying to sell their homes. We couldn't get responses or anything. So this would kill that association because those people put in requests. Nobody called, nobody responded to emails, and they basically would have a great lawsuit. They could file suit in justice court and get a $5,000 judgment like that over the failure because you're harming somebody in being able to sell their home. Yes, ma'am.
Even if the management company is responsible for providing that resale certificate, if someone contacts the board,
Yes, ma'am.
they don't respond,
It's the association.
it still could be sued.
Yes, ma'am. Management company's not sued, the association is sued. Yes. That's why you gotta be careful, and that's why you need somebody like Sonia and her team at Marshall Management. They don't put you in jeopardy. All right, and the legislature, you'll see throughout the statutes, the next thing they added here is not only can they get the $5,000 judgment, but they can get court cost and reasonable attorney's fees. They've gone through the statute and added the word reasonable to attorney's fees. We have to prove up reasonable and necessary attorney's fees anyway. I can tell you right now, whether it's in the statute or not, we've got case law that says it. The rules of professional responsibility say it, so we have to do it anyway. They just, I guess somebody wanted to say, hey, let me add something, the word reasonable. And we all know how reasonable attorneys are, so we really didn't have to add that. Yes, ma'am.
I'm so glad you said that, because my question was, what is considered to be reasonable? Are we talking about something that's an hourly rate, or are we talking about something that's daily? What is the government considered?
Here's kind of the rules that judges apply and everything else. When we prove up attorney's fees, that's why we'll do detailed invoices, because we've got to show that our experience, the type of case it is, the type of work that was done, how much work was done, the hourly rate that was charged. Judges take all that into consideration, because some cases you may think are only going to cost you, say, $2,000, and because the other side is very aggressive, they stand in your way on everything, it'll end up costing you 10. Because of the situation and what was going on in the case, that 10 can be very reasonable. And judge, because every case is different, every attorney we come up against is different, so that's why we prove it up like that. Just the difficulty, the problems we had, what all we did, and everything else. So that's how we prove up what is reasonable and necessary in the cases. Yes, ma'am.
So if you're not dealing directly with, or if an attorney is not representing you, or if you're not dealing directly with the judge of a case, if it's just between you and that attorney that's representing the association, are you, the homeowner, entitled to all of that you just stated?
What you can do is, like, if you're pro se, representing yourself, and the association has an attorney, and I tell a homeowner who's representing themselves, I say, well, here's the attorney's fees you're responsible for. They will say, give me a breakdown. I will provide them with a breakdown, because I'm asking them to pay, and if we were in court, I would have to provide that breakdown for them. Now, what we will do is we'll redact out the privileged information, because my invoices will have in there conversations I had with the client. It may have details. It may have information that I sent to the client. We have the right to redact that out. We take a black magic marker and just mark it out. But as a homeowner, when I'm asking them to pay attorney's fees, yes, ma'am, I will give them a detailed breakdown of my attorney's fees.
Okay, is that something that's automatically given, or that's something that the homeowner has to request?
You're going to need to request it. If they're asking you to pay attorney's fees, you have the right to request it, and they should have no problem giving it to you. Okay, yes, ma'am.
Does this include any documents that the homeowner might request from the association?
Does it include, you can go on, ask your question in there.
Does this include any documents that a homeowner might request from the association? Any type of
No, well, I can tell you right now, what you need to do is, if you want to request documents if a member wants to request documents, they need to put it in writing and send that request to the HOA. A homeowner is not allowed to see the files of another owner, nor are they allowed to see anything that falls under the attorney-client privilege or attorney work product. So when people make requests, and let's say if it's headed toward litigation or it's already in litigation, then I'm gonna look at everything that's coming, and I'm gonna pull out everything that's privileged. But with regard to, like, financials of the association, you have the right to see those. You have the right to look at what they're spending their money on. an audit. If an audit's been done, you have the right to see your own file except for any privileged information that's in there. So it's very broad what you have the right to see. We're just limiting it to your information, and everything that's privileged is pulled out of it.
What if you send them your first request? How many days do they have to respond? The first request.
How long do they have to respond to the first request? They basically are going to give you a response within 10 days. They're going to tell you. And we're not dealing with resale certificates here. That's not. You're dealing with another section of the property code. Okay? Yes, ma'am.
Oh, I was just gonna quick ask, can you bring in your bylaws that the files or the documents as far as the budget is concerned has to be requested by an attorney, and it cannot be requested by a homeowner? Does this supersede that?
Yes, ma'am.
Okay.
Yes, the statute is what everybody's got to go by.
Okay.
All right?
Even if it's written in your bylaws?
Even if it's written in your bylaws, they've made it uniform for to take care of the problems. All right, let's see, where are we? 207.006, if you are a subdivision less than 60 lots or you've contracted with a management company, then this applies to you. So even if you're less than 60 lots and you've contracted with a management company, you have to have an internet website. And usually those websites are provided through a management company, but if you are self-managed, you've got to get an internet website. It's now the law. You've got to have one. And on that website, your members have to be able to get access to the association's documents. So if you're self-managed, do that, get it done. That's going into effect September 1. And it's very important that you have it. Yes, ma'am.
I'm so sorry.
That's okay.
The question I was gonna ask is also on that website, do they have to have information for how you can contact a homeowner association or how you can contact the management company? Because can they say that you can only get information from the management company, we the homeowner association will not provide this?
Well, usually if a homeowner association has a management company, that's who you go through. That's why they have them. So the management company provides it and the board members don't have to bother with that. You go through the management company. The legislature said, with regard to the website, they're just concerned about having documents available to the association members. And usually it'll have on there their management certificate or who to contact with regard to getting information. They do have to have a management certificate, and it's got to be filed now with the Texas Real Estate Commission. So after December 1, if you cannot find that information, you'll be able to find it on the Texas Real Estate Commission's website.
Right, I understand that. The reason why I was asking is because can your homeowner association or the management company block you from the website so that you can't access that website or that information because they have passed you keys?
Well, you can't be blocked anymore. You can't. I mean, come September 1, everything's got to be on there, and that management certificate will be on there. That'll give you all the contact information, but you can't be blocked at all. Yes, ma'am.
So if you request the name of the president of the HOA of the property owner group, they're supposed to be.
If you request the information of the president, the personal information does not have to be there. If they have, the management certificate will basically say who is the designated representative to contact. The president or vice president or anybody else on the board, they don't have to give out their personal information. They may have even if they're self-managed, they may have a special line that people can contact and a special email address. They don't have to give their personal email, personal phone. The names, all they have to do in the management certificate is list a designated representative, the person that needs to be contacted. It's not, they don't have to list, the legislature has said you don't have to list the names and private information or anything else of the board members, just a designated representative.
Our
And-
Homeowners Association Management Company has their website, and our documents, they list all in one section, all the properties they manage. Our documents are attached there. It's public information.
Yes, ma'am.
Our homeowners board, a couple years back, contracted to have a second website, secure to residents only, that we use to communicate and disseminate general information, you know, new garbage schedule changes, anything pertinent. If our gates aren't functional, just a method of communication. But we have not housed any of the dedicatory, can't speak that word, instruments on that site. Would it be wise to put a note on that second site to refer to this other site?
I would.
For those instruments?
I would, just so they know where to find them.
I don't want to have them in both ways, because then you get into a conflict if one's updated and the other isn't.
Right. Just put a note that in the private area where the only members can go, say, the governing documents are located under whatever category on the main page.
Okay.
Yes, just refer them like that. That's fine.
All right.
Yes, ma'am.
If our HOA is self-managed, are they allowed to charge it, to pay the person that's managing, even though they're an officer on the board?
You absolutely, well, we've got a section of the property code, and we will hit that later on because they made a few changes to it. But if the board has basically taken in bids and they have looked at other people who were interested in managing it, and and the person who on the board who was put in their bid also to be a manager, they were not involved in the process, they were not involved in the voting, they didn't look at the bids of the other people. If that happened, and y'all chose that individual, yes, you can. But that needs to be detailed in a resolution, and I would definitely make the homeowners aware of it. I would have had that just open board meetings where we're looking at this, we have a board member who's interested, so nobody can say that y'all were doing anything underhanded.
So what do you do when you have an attorney that supports that, even though he knows it's illegal?
You need to change attorneys. You need to get rid of that attorney, okay? Call me, because we're not going to do it illegal, all right? Yes, ma'am. Here he comes with the mic, ma'am.
Access to our community. We can't get in our community. The board is basically doing everything without the community's vote and involvement. It's totally legal, and I'm gonna just say that. Even down to the lawyer, he is preventing us from doing what is necessary. So where do we go and who do we talk to about that? Because it's very illegal. Our money, things are being spent. And many of us here have asked for the documents for over years and have not gotten it.
Right.
So I need to speak to somebody.
Right. Well, you can contact me. The last 2 or 3 years, I've been involved with, not as the illegal attorney, but as the attorney who's been going after people who have taken over boards and running them like a dictatorship or like a family trust account.
That's what they're doing.
And so you can stop them. It'll be a fight, but believe me, we can get results with the courts. The judges don't like that going on. They do not. They're very concerned about y'all's money, and everybody, and the legislature is too. That's why these statutes have come about, to make it to where people do things out in the open because they're spending your money, your hard-earned money.
And go to the state bar on that attorney.
Yes, ma'am. Thank you, and I will be talking to you after.
Okay. Any other questions? All right, let's keep moving on. Y'all are a good group. Oh, this lady. Yes, ma'am.
I
So you've heard HOAs have a lot of authority? You know, I would have agreed with you in 1995. Because we did have a lot of authority. It was a wild west, and there were no laws really on this, and we just went to town. But the horse has been put in the stall. The legislature started it back in early 2000s, and they've been tweaking it ever since. And this, listen, the HOAs used to, and they have authority, and they need authority to enforce your restrictions, because they serve a very important purpose in protecting your property values, and they do. But there are some, just like in anything, there are some bad apples that get a hold of an HOA, but we can get control of them. I've done it recently where I've had to step in, help homeowners and members get back control of their HOAs, and now they're running smoothly again. But it takes time, it takes money, and believe me, it may take a couple of years to fight that fight, depending on how hard they hang on and try to hang on to that power. But even though I represent HOAs, I want them to do what's right with the people who live in the subdivision, spending the money, enforcing the restrictions, and everything else. I practice law from a standpoint of, if you bring me a case and I look at it and think, I would look like a biggest fool standing in front of a jury trying to convince them to stop this person from doing this, we're not going to go any further than that. And because we're not going to win, we're not going to recover our attorney's fees. And I'm talking from a standpoint of, like, if somebody's leaving their trash can out, there's other ways we can deal with it. If we sue somebody over just a trash can being left out or put in the wrong place, we are going to get drop kicked. And we're not going to recover any attorney's fees from that. And plus, I'm going to get chewed out by a judge for wasting everybody's time. So we want to be reasonable in what we're doing, but an HOA, it's there for a reason. And it's to help out, keep your property values up. That's its whole purpose. And if you've got one that's out of control, come talk to us. There are ways we can bring them back. Judges want to see that too. I can tell you right now, we've got some great judges who are trying to protect your property values, but your rights also. Okay? Anything else on that? All right, let's move on. Yes, ma'am.
I wanted to know if you had a previous management company and now you have a new management company, and the previous management company is refusing to turn over your documents, the attorney wants to charge you to get those documents, what can you do about that?
They want to charge you to get them?
Yes, ma'am.
And they're owned by y'all. I mean, what you can do is you can file a lawsuit. A judge is going to make them turn over those documents. If they refuse to, then that's your only option, and you can basically sue. Now, there's ways to delay it, and if they fight you, it's going to be a fight. I'm in one right now where we're trying to get a former board member to turn over documents. So it can be a battle. You just got to be willing to hang in there. Okay? Be a fighter and hang in for the long haul. Yes, ma'am.
I have one more question also.
If that does happen, what you just described, and we sue, let's say we win, is the other side going to be required to pay the,
Attorney's fees?
Can we prevail in a way that the other side is required to refund, legal fees?
Yes, ma'am, but here's what you need to keep in mind. If that person is not just ultra rich, or they've got if you sue a former board member, if they will turn the claim into the insurance company, then the insurance company is behind that. They'll reimburse you for attorney's fees and everything else. But if that individual is not covered by insurance, y'all got to remember the state was created by debtors who were running from their creditors. So in the state of Texas, we're all protected, man. And you can be middle class and have a $10 million judgment against you, and they are not getting your car, they're not getting your homestead. If you're married, $60,000 worth of home furnishings, they're not garnishing your wages, they're not getting your retirement. So that piece of paper, you might as well take it and shred it or hang it on the wall. It's worthless. So you have to go in it from a standpoint of, if that person doesn't own a bunch of other pieces of property or some valuable stamp collection or a Van Gogh or something like that, you're not going to recover those fees, so you kind of have to look on them as a business expense, like a lot of businesses do. So keep that in mind when you're going after people. You may never see that money in hand again. All right? You can put a judgment against them. It can go on there. It'll attach, the credit reporting companies will pick it up. But that judgment is gone after 10 years, a money judgment, unless you renew it before that 10-year period is up. So sometimes it's not worth chasing them. Just leave it. Now, I can tell you right now, if you get a judgment against them, know that, okay, they probably can't pay it. But one time I did. 3 years later, I get a call from some guy sitting in a car dealership. What? Why do you have this judgment against my record? They're making me pay it now. I'm like, great. I said, let me pull that judgment up. We're going to add up the interest on it. And so before he could buy that car he wanted real bad, he already had that taste of that car in his mouth, he had to pay our judgment off. So, you just got to sit back and wait. If they want to get life insurance, judgments will show up. If they want to refinance their mortgage, judgments will show up. And those mortgage companies and the life insurance companies are saying, clean up the judgment. So you can sometimes you collect them and don't even expect it. It's like an early Christmas with stuff like that. All right, management company. It's a person or entity who's established or contracted to provide management or administrative services on behalf of an HOA, Property Owners Association. So it can be a person or entity, and if they're established or contracted to provide those services, then they fall under the definition of a management company. All right, so even if you're self-managed, like that lady said, and you've got a board member who's managing it, they fall under that definition. So everything in here is going to apply to them that applies to management companies. If they're not what? Certified. They don't have to be. They can just be Joe Blow, and as long as they are contracted or they're established and they're providing some type of services for that, or any type of service for that POA, then they are considered a management company. This is pretty broad, because the word established, I don't know what that means. And the legislature didn't define it for us.
So what if you ask for a copy of that contract to show that they are contracted and
You should have the right, you have the right to see it.
I've asked the attorney and the homeowners.
Have you done it in writing? Have you done it in writing?
Yes.
Okay. Come up to me and I will show you the section of the property code. I think it's 209.051 that talks about exactly how to ask and how to ask. It needs to be certified, okay? And whether you're asking for copies or just to inspect it.
Okay.
All right, two ways you can ask for documents. All right, management certificates, 209.004. What the legislature did is they came and they're tweaking this a little bit with regard to management certificates. And here is where you have to give the name, mailing address, telephone number, and email address, either of the person managing the association or a designated representative. So where this is concerning for a lot of management companies is, sometimes somebody will be managing the association, then they pass it on to another individual. They don't have to put the actual manager. They can put like a designated representative, like Sonia. She's going to be with her company forever. So we could put Sonia as a designated representative on all the management certificates. That way, we don't have to keep changing them every time a manager changes. And you've got to now put your website address in that management certificate. And it's very, very, very important that whenever anything changes, you file an amended management certificate in each county where your property is located, because some subdivisions are in 2 counties, some are in 3 counties. Make sure it's filed in each one of those counties. If it's not, we're not in compliance with the law. And then the next section they added deals with filing that filed management certificate. So come December 1, we have to take that filed management certificate where the county has stamped it, and we have to file it on the website of the Texas Real Estate Commission. And we have from December 1 until June 1st, 2022 to get that done. But every time it's amended, you've got, once June 1, 2022 is passed by, within 7 days of it being amended and filed, we've got to get it filed with the Texas Real Estate Commission. Now, the only reason they're doing that is it will make it easier for title companies, for realtors to be able to locate them, because once they're filed with the county in the property records, it gets too confusing. So here, this will just be a regular site where everybody can go to. I hear that the Real Estate Commission's having problems getting it set up, but they'll get it done by December 1. All right, go to page 6. Now, you're not going to be liable for a delay in filing this unless it's done willfully or caused by gross negligence. So, like the ladies were talking about earlier, where the boards and the management company are just not doing anything, if they're willful or grossly negligent and not getting these management certificates updated and filed, then they are going to be liable. Otherwise, if you're trying to get it done, you can show them trying to get it done, then you're not going to be liable. Yes, ma'am.
So the HOH is responsible for filing the management company certificate?
When we call it a management certificate, what basically, and that's just more of a slang, in the property code, the legislature has basically said that you have to file a document that essentially identifies your association and identifies who the contact information is, where all your governing documents are filed in the property records. So we identify it by under the clerk's file number. The declarations are filed under the clerk. We put the clerk's file number, articles of incorporation, bylaws, rules. All those are listed. You'd also state the name, address, email address, telephone number of the person who can be contacted by like a title company or a homeowner or anybody else for information about that association, and your website information. So it's just kind of usually like a one-page sheet unless they have a lot of governing documents, but everything about that association is on that document. And that is what we call it a management certificate. You file one whether you have a management company or not. It's just an affidavit. That's filed in your county records, and now that document, after you file it, is sent to the Texas Real Estate Commission and filed on their website after December 1. Yes, ma'am.
The management company has until June of 2022 to file these documents.
From December 1 to June of 2022 to get everything done, to get the management certificates filed with the Texas Real Estate Commission. Okay, go to page 6. Oh, yes, ma'am.
That would be June 1st and not June 30th.
June 1st, yes, ma'am. 2022. Yes, ma'am.
Good morning. Just want to piggyback on a question the young lady just answered here. Is it the HOA responsibility to file the management certificate?
Yes.
Or is it the management company?
Management company will do it for you, but it's the HOA who is ultimately the responsible making sure it's being done. Okay?
The management company can.
They do it. They will. Everybody who I work with who is managed by a management companies will contact me and they'll say, hey, Susie, we need this filed. Let's say they're amending their bylaws. We need this amendment filed, and then we need the management certificate updated. So they contact the attorney, and we get everything filed and updated. So we'll get the bylaws filed, then refer to them in the management certificate when we update that. Then we send it back, and the president of the board will sign it. We get it filed. So ultimately, it's the attorney who's doing it, but the management company will tell us what to do. Okay, if you fail to, look at page 6D, if you fail to file a management certificate or amend it, then a lender, purchaser, or a title company is not liable to the association for any amount due to the association on the date of a transfer to a bona fide purchaser. So basically, you're not going to be collecting your money. Yes, ma'am. No, ma'am. No. Usually that information is not included on there about who the officers and directors are. No, that's not included. It's not mandatory. If you want to include it, you can, but that would mean that would be hard to keep up with. Usually it's just the governing documents and contact information. All righty, so keep that in mind. If I wouldn't put that on there. That may be on your website or somewhere else, because that's too hard for us to keep up with. We don't want to get in trouble and they say, we have a new president. I don't want somebody saying, oh, wow, I didn't amend it, and then this kicks in to where somebody can use that not to pay you the money that's owed. All right? So it's very important. We don't want to lose money by failing to keep those updated. So it's very important to amend those. And basically, if you look in E, it says any lien filed by the association that fails to file the management certificate or amend it, then on the effective date of a transfer to a bona fide purchaser, you are not going to be able to enforce any amount incurred after the effective date of the sale. And an owner is not liable for attorney's fees incurred that related to a delinquent assessment or interest on the amount of that delinquent assessment if you did not have that on file. So let's say you have been in a battle with somebody and you've got some litigation going on and your attorney's fees are already up to $5,000 on that, and you've been suing somebody for delinquent assessments and you've got interest and everything. Then come to find out we didn't amend our management certificate. We've just given them a great argument. And a judge is going to read this and say, oops, you're not going to recover your attorney's fees or interest. So they've really put some penalties on us to keep up with that stuff. So what we need to do is calendar it and just check, make sure, has anything happened? Anything have been amended, and so that any new rules been put in place, and we need to amend our management certificate, or we've amended our bylaws, let's get them filed, get that management certificate amended too. Because we don't want to get popped with something like this. 209.00505, Architectural Review Authority, that the legislature is dipping their toe in this water. Never before have they talked about the ACC. They are now. This only applies if you have more than 40 lots. It doesn't apply to a developer. So if anybody's living in a neighborhood where you've still got a developer under control, this does not apply to them. However, they've now said if you're a current board member, the spouse of a current board member, or you're living in the house of a current board member, you can't be on the ACC. And that limits a lot of HOAs, because that's our volunteers to be on the ACC. What you need to do is look at your governing documents, and if the governing documents don't say that the ACC can only be members of the association, if they don't limit it to that, then your management company can basically step in and be the ACC. However, they're going to charge for their services for doing that. Why they did this, I don't know. I mean, I guess they think that y'all got volunteers just showing up every day to do the ACC. So If you're self-managed, then you're gonna have to, I don't know, act like you're holding the lottery or something and invite people to, we're giving away hot dogs and whoever gets the short stick, you're now the ACC. So, come September 1, it changes with regard to Architectural Control Committee. Yeah. All right, and so a decision by the Architectural Control Committee can always, they're basically saying it can be appealed to the board. So if somebody doesn't like what the Architectural Control Committee said, then they can appeal that decision to the board. Yes, ma'am. No longer. Comes September 1. That's what, I'm sorry? Well, that's how it usually ends up because we can't get volunteers. Well, do y'all have a management company? Well, then the management company, if they're not forbidden in the governing documents, then the management company can basically act as the ACC and just go, take everything before the board. Because a lot of what people submit is, and we'll get into this, is let's say somebody says, I want to paint my house cobalt blue. You say, absolutely not. But the legislature encourages you now to essentially say to that person, paint it, here's the paint colors we approve. These are the ones we approve, so submit your request based on this. That's what they want y'all to do with people. Show them how they can fix what, if they've already put something in, show them, give them ideas on how they can fix it. They want you to do that, to try to avoid litigation if you can. But if somebody wants to, if you see them and they're already starting on a roof and you're like, stop, show them what kind of roof they can put on. What colors or what type of shingles are that y'all will approve. Yes, ma'am.
So, right now, I go to the property management group, and then she takes it, I guess, to the board, but she gives me the runaround, so she's getting paid to do that.
I'm sorry, say that again, ma'am?
She's getting paid to give me the runaround and dragging that, what you just said. Computer. She's making money off of that.
Right, the board president?
Property management, when I go and submit something, she'll give me the runaround, but she's getting paid to give me the runaround.
She's basically saying the property management company is getting paid to give you the runaround?
Pretty much, according to what you just said, because I'll submit something, she'll say, oh, the color of the door, I went through months and months and months of emails. She tried to get the color of the door straight, so she's getting paid not to give me she knew the answer.
Well, this is where the legislature addressed that. If you look on page 7 in D, they're saying, when you deny it, give a reasonable basis for your denial and show them how they can fix it. So they're trying to stop that if that's happening to you, if you're getting the runaround. They're saying, tell them how they can fix it, what will be approved, and then you can resubmit something and say, here you go, I've done what you said, now it should be approved.
So where's all of this information? Where are you gonna find it?
Where can you find what information?
The information about what colors are okay, what,
That would be, that would be your particular neighborhood. And what a lot of associations do is they may have it on their website and say, these colors are the approved colors. I have some associations where they have it on there that these are the approved colors for painting your home or your shutters or doors. Yes, ma'am.
I'm lacking because the first time I owned a home, I didn't even know about a homeowners association. I got no information or anything until I started going to the meetings. So, like she's saying, how would you find out this information if you don't know? How would you find out?
What
The homeowners association is gonna come to you and just get you.
do y'all have a management company for your association?
We do now.
Okay.
I mean, we did before too,
But Sonia's is yours now?
yes.
Okay. All right. Contact Sonia and them and they'll tell you.
But I'm just saying, when I first.
Yes, ma'am.
30 years, I'm
Right. Well, under the law, the title companies are supposed to make people, when you go to buy a home, they're supposed to sign something and say, and I know a lot of people shake their heads like, oh, that didn't happen with me. So, but they're supposed to give that so that people aren't like y'all where you're sitting there going, I didn't know this when I purchased my first home. They're trying to get the word out and let people know that, yes, you are restricted. And a lot of associations even have welcome packets because they know they're getting into that more because they know that they may have not have been given the information at the closing. So they'll have a welcome packet and say, hey, here's our website, here's our restrictions, that kind of stuff. So,
Question of clarification. In the laws, if it's referred to as a condominium, can I assume that also would be applied if we're labeled as a townhome?
all right, here's the test for a condominium and townhome, because that can be confusing. Basically, the Texas Uniform Condominium Act says that if the owners own a percentage of the common area, if you look at your governing documents and it says that the owners, if your unit is so many square feet, then you own, 10% of the common areas. If it's this, it's 3% of the common area. If it states that, you're a condo. If the association owns the common area, you're a townhome.
Okay.
What about solar?
So if
I'm sorry.
we have, okay, so then that answers that. But going back to the ACC, so if someone wants to put a storm door on the front door of their home, they submit the ACC form to current management company. The management company sends it back, reviews it. If it's grossly not within the rules and regulations, they decline it. But if it so far looks good and they pass it down to the board member, rookie me, for approval, does that fall within the new standards?
Are you a townhome?
On a townhome?
Yes, ma'am. You're going to be covered by this. Condominiums are not, 209 does not apply to condos. But if you're a townhome or single-family residence or duplexes, this applies to you.
Yeah, all the townhomes are duplexes, and I've got to go back and look at that lot information, because I'm not sure if it's one lot with one building and two townhomes, if that's counted as one or two.
Okay.
Because if it's counted as one, I'm under three.
Well, if you have any questions, you've got my number on here. You can
Find that plat figure.
yeah, you can give me a call.
Excuse me, my question is about solar panels. I'm here.
Okay, there you are, sir.
About solar panels, about the locale, if it's drawn up in the legislature, or is it, can a homeowner or the property owners, can they restrict the location or anything, any information about solar panels?
Yes, the legislature's left that pretty open, but what you can do is the only way that you can stop the solar panels is, and the solar panel companies know this, so they'll submit it and say that if we had, these are the best place for the panels, if they were anywhere else, then it would reduce the percentage of power and electricity. So they know the language in the statute. The only way you're going to stop it is if the property that is contiguous to, okay, that's the people who are touching that property, so that's going to be on 3 sides. If those people basically completely objected to it and had a basis for that objection, so that's usually not going to happen. And because the standard is very high, they can't just say, oh, I don't agree with solar panels. That's not an objection. So the companies that put them in know the language, and it's very hard for us to stop them and where they put them in, because they're going to say, well, if I moved them, I decrease it by 10%, it changes it, and therefore the legislature says then you don't have to move them, because they want that person to get the maximum benefit from those panels. Yes, sir, did you have a question?
I have a question.
Oh, yes, ma'am. I'll get to you.
with the legislator or legislation in the community, what can the HOA do about homes that's running businesses within the community and like halfway homes, ill children?
You know, they're very protected by the legislature, and you're not going to really stop them. Now they are regulated from a standpoint of how many people they can have in a home. They can't just put a bunch of like say they're taking care of mentally handicapped children or adults. Then you've got to look at the size of the home. Well, how many people does that home really hold or should hold? And so you look at it from that standpoint. And they are regulated. However, the case law out there, we're not going to be able to stop them because the legislature looks on it as, you know, they have the right to live in homes in a neighborhood too. If you're having problems with some of those individuals, like if they're not being monitored properly, then we need to get in touch with the state and let the state know, because they have jurisdiction over those people who are caring for them. They should be caring for them and not because you're putting that handicapped person in jeopardy if you're not monitoring them. So if that's happening, contact the state and let them know that they're not being monitored properly or cared for properly. Yes, ma'am.
In the instance that, when you said that the legislature now limits the number of people that can be in these, was that in this last legislature period?
No, about handicapped people and stuff?
Yes,
No.
number of people that can reside there.
No, they didn't. What she's talking about is there are homes that are in neighborhoods to where they're providing homes for. The legislature did not address that, but you have statutes that are already in existence where people have been certified to do that kind of work. And so the legislature, in those statutes that have already been on the books, have said you can't move into a 3-bedroom home and put like 10 people, 15 people in there. Plus, you're supposed to monitor them. You're supposed to have somebody living there who's watching, like a house mother or house father watching over them. You need to, if that's a problem, if they're not doing what they should be doing, contact the state. They already have statutes on file. They didn't address that at all in this.
That was my question. Was this addressed in some formal legislation?
Former.
And not, or was it addressed in this?
It wasn't addressed here, but it's on the books.
Okay.
Yes, ma'am. Yes, ma'am. Yes, sir.
You know, in the city of Houston, like 211, 311, they can be used for some of these circumstances, huh?
I'm sorry, what was that, Johnny?
211 or 311, like the city of Houston, I don't know what municipality you live in, but they do have another outlet to report some of this stuff.
Okay.
For oversight, don't they?
Yes, sir, they should. The city, if you're in the city, then the city would have, they probably have a contact number for that. But if you're not in the city, then contact the state of Texas. Yes, ma'am.
I would like to circle back to common area that is owned strictly by the HOA, like 0 lot lines.
Yes, ma'am.
If someone crosses that boundary and puts a structure or a patio, something like that, what does the association?
Will they not remove it?
Yes.
Have you asked them? Have you let them know that they're on your property?
Yes.
And they won't do it?
It's a struggle right now.
Then you're going to have to file suit. If somebody won't remove it, then you need to get suit filed because, listen, if it's open and obvious and it's on your property and you do it for 10 years, the legislature and the courts look on it as, well, you didn't have a problem. It's theirs. And so you need to do something about it after you, and I would, have show that we've sent them letters. If it were turned over to me as an attorney, I would send a demand letter saying it's got to be removed. And then if they don't, you need to file suit. Otherwise, you're going to lose your right to say something.
But it would not be trespassing if we sent a contractor onto our common property to remove that. It states it in our bylaws.
What they build on there?
A patio.
And how far is it on? Is it like concrete patio?
I'm not really sure what the subbase is, if it's just, a crushed something with patio papers on it.
Just be careful if you go out there and start busting something up and you ruin their part of it, I would be real careful with that. I would rather have because what if you do that and they come back and put it right back? I would rather go the route, and it's not just because I'm an attorney, but if somebody did that on my property, if I'm gonna cut, let's say I take a saw and cut it, and they say, well, you've damaged my patio now I've created a cause of action for them. Or if it's concrete and I bust up the concrete and it cracks their concrete, then I've created a cause of action. So it stops people from ending up in a high noon having a shootout with each other. Just be careful with that, with removing something off your property yourself. And it's just because people are so ready to beat each other up, shoot each other.
But it's like theft of property because they, cross their boundaries.
Right.
But there would be no way for the HOA to sell that portion.
Right, but, and the thing is they may respond to an attorney's letter and say, whoa, wait a minute. And what we even do with people is, even before we file any lawsuits, we send a copy to people and say, we're serious, we're gonna file this. And we get a lot of response from that because people think, wow, okay, here's my name on a petition that's fixing to be filed with the courts. So I would definitely do it, and the court will enforce it, and they'll make them move it, or they'll give you the right to remove it. I had somebody one time years ago, they had put in a horrible junkyard at the front of a subdivision on property that they owned. And, it even had the junk cars that were smashed and the metal fencing around it and the Velvet Elvis pictures and the old refrigerators and stuff. And so we got the judge to rule in our favor, told him to remove it, and they got so angry with us that they go and make these big old posters of the board president and her husband as like she's a dancer. And they were like 8 feet by 8 feet, and they put them at the top of the building that was on that piece of property. And so, we wanted them down. So what I did is I filed a motion for contempt, went before the judge, and we had pictures. And I said, Judge, and the guy was there, and I said, Judge, we're here, and here are pictures of what he's put up after you awarded us a judgment for him to clean up all the rest. And I said, we're ready to put on testimony. And he said, Ms. Rice, have you ever heard the saying, a picture's worth 1,000 words? I said, yes. And he looked at the gentleman and he said, do you have your toothbrush? Because you are going to jail. And I got the judge, while he was sent to jail, to give me a judgment, give me an order allowing us to go take it down. Because I didn't want this guy to say we trespassed. I didn't want him to say we damaged anything, some great work of art. So I let the judge give me that right. And that's what you want to do. It saves us from a lot of heartache down the road. So keep that in mind. Yes, ma'am.
Good afternoon. In relationship to businesses in the homes, what does the law say about that? Especially those businesses that go out onto the lawn, they're constructing things or manufacturing things. I know inside the home could be whatever. You want people to have whatever they want to do to us. What about that? We have neighbors complaining.
Well, do y'all have anything in your restrictions? What you want to first look at is your restrictions to see, do they prohibit businesses, any type of commercial activity? Look at your restrictions and see what they say. Now, do any of y'all have Airbnbs in your neighborhoods? All right, those have become very popular. Now, with Airbnbs, the Texas Supreme Court in Tar versus Timberwood said they're not businesses. You can't shut them down based on saying you have single-family residences. But they did say if you have restrictions that forbid them, you can enforce them. So in order to stop them, you can amend your restrictions, and we've had some associations do that, to where we say you can't enter into a lease that's for less than 3 months or 6 months or 1 year, whatever you feel comfortable with. And it saves you, and so that you can shut down Airbnbs. Otherwise, if you don't have that specific language, we're not going to be able to shut them down. Yes, ma'am.
Businesses,
with him. We sent out notice after notice after notice. He's been to court. And he just seems to move the cars around and continues to do it. It's very clear to see a car jacked up, hood up, continuously. It's in a cul-de-sac, so, you know, that's an area that makes that most certain people are coming in. You can't go out every time you're in that area. It really is to the point where it easily causes an accident, and that's the bigger part where we're trying to go with this.
Have y'all filed suit against him?
Well, also, we talked to the city, and the city saying that it's not a business because you have to see money exchanged. And I mean, of course, how can we prove that it is a business? Because like she said, that we do see the cars all the time, the hood is up, the tires are missing, and it is definitely that he is working on cars.
Right.
And getting money for it. But like I said, the city said that, well, how can you prove it because you don't see the money being exchanged? And that's kind of like stupid because I can go in the house and get my money.
Right.
But you pay for the service. So.
Well, what the city's saying is gonna be different than what we would use to prove in a lawsuit. And we could prove there's been some money exchanging because we can do discovery. We can take the man's deposition. There's many ways we can find out if money's being exchanged. And since he's jeopardizing the health and safety, you know, by all those cars being there, that's very important because that then kicks in what we call the English common law, which is before we had common law in the statutes, you had English common law, which you can't jeopardize the health and safety of people with stuff like that. So there's ways to get somebody and stop that. And the city's limited by the statutes they can operate under. And so we in the courts are not limited by what the city's qualifications are. We have a lot more to work with, a lot more statutes.
So this is our situation. We actually have filed a lawsuit. And now we've discovered that the owner of the house is deceased. And so now our attorney is like, okay, now we gotta find out who's the owner or the next of kin. Well, talking with the community and people in the, you know, very disturbed by it, someone has mentioned to us that the owner was deceased and that the son is provided, but now, so we're kind of stuck with the attorney. We know that the owner is deceased and the son is living there, and apparently he's the one and his mentee working on cars, but where do we go from here? I mean, our attorney.
There's ways. There's ways. I'm after people who, I've got a case right now where the son's living in the home and I got the son and the dad is still in the dad's names, but there's ways. There's ways to do it. Come talk to me afterwards. There's ways to do it.
Thank you.
Yes, ma'am.
What are they saying, or legislators saying, or has there been any changes about group homes?
About group homes?
Group homes.
Nothing.
So,
They have not said anything. They're just allowing them.
okay, if it's how many occupancy is it?
That's where you get into the size of the home. And that's going to be under different statutes. It's a different area of law, and there's certifications, but that's where, when we were talking earlier about the size of home, the number of people living there, and whether they're monitored and how they're monitored.
Everyone, I'm
Yes.
gonna have y'all wait to hold and ask your questions at the end because it's gonna prolong the seminar and there's other people that need to go on about their day. So just hold them to the end and we'll come up to us afterward and we'll address them. Thank you.
All right. Robin's got me under control here. All right. Basically, if you look on page 7, you've got to hold a hearing within 30 days after the owner requested. You can postpone it if you and the owner agree on a postponement. Keep in mind, guys, that now they're allowing these meetings to be audio recording of the meeting. All right, and what I want y'all to do as board members, I want you recording those meetings. Make sure you're recording those meetings. All right, because even if the homeowner doesn't say it, they're probably recording it. They're going to put their phone on that table and it's going to be recording and you not even knowing it. What you've got to do is also, if it's a belligerent homeowner, let's do a video recording so that we can show that to a jury down the road or a judge. because by the time they get to court, they're going to be under control because their attorney has talked to them about keeping everything under control. So videotape it if they're really aggressive, if they're threatening you, cussing you, and save that videotape for us. Okay, page 8 is basically, this deals with open board meetings, and if you'll go to page 9, the reason we put this out is because the legislature has made some changes. When you give notice of a regular board meeting, you've got to do it, you've got to give them 6 days notice now. Not 3 days, you got to give them 6 days notice of a regular board meeting. If it's a special board meeting, you give them 3 days notice. Okay? And everybody knows how to give the proper notice. I know Sonia and them do. Yes, sir.
If it's a regularly scheduled monthly meeting held on the same day each month and published as such, does that constitute?
That's a regular board meeting.
Regular board meeting.
Right. You make sure you've given them at least 6 days notice of that. Yes. Now you've got to do an agenda with that too, because you've got to give them a description, a general description of what your meeting is going to cover. And if you're going to have executive session, of general overview of what you're going to discuss in executive session. All right, so an executive session is where you discuss the legal issues, personal issues, if you're going to pursue litigation, if your attorney's giving you an opinion to look at, that's all done in executive session. When you come out of executive session, then you just give a general overview of, you say, we talked about pursuing some people who were delinquent in accounts, and we're going to turn those over to the attorneys. Don't give names, don't give addresses. Yes, ma'am.
Please, y'all, please hold your questions to the end. I promise you. I know we will.
Okay. You're not going to be able to get executive session.
Right, but any other board meeting?
The other minutes should be available for you. Yes. Okay, with regard, on page 10, these items from fines to the election of an officer, those must be done in an open board meeting after you've given notice. So these, if you're going to discuss these items, they need to be done in an open board meeting. When they talk about initiation of foreclosure actions or initiation of enforcement action, then what y'all have got to do is don't say we're fixing to sue Joe who lives at this address. Just say we discussed an executive session and we are going to pursue enforcing delinquent accounts or enforcing deed restriction violations. That's all you need to say. Don't get into detail in that. Or with fines. Don't get into detail of who you're fining. Just that you are going to be enforcing the fines, and make sure people are aware that you're able to fine. And if your deed restrictions don't say you can fine, don't fine. Do not issue fines. There is no state law allowing you to fine. There's no county statutes allowing you to fine. It has to be in your deed restrictions that say you can fine. If it doesn't state it there, don't do it. You don't have the right to do it. Okay? Those are uncollectible. All right, association contracts on page 11, 209.0052. If you'll look on, these are the contracts we talked about earlier with that lady. On page 12, the legislature basically said that if you're going to contract for services for more than $50,000, you need to have a bid process and follow that bid process. If you go out for bids and people don't respond, keep your proof that you submitted asking people to give bids. If you only get one bid in and use them, you're okay. But just keep proof that you tried to get bids and were unable to do it. How many of y'all use credit reporting companies? Okay, the legislature's addressed that. if you're going to report any delinquency of an owner to a credit reporting company, then you need to put that in your notice to that owner. Make sure that they are aware that you're going to be reporting it to a credit reporting company. I'm going to go through this a little quicker. Go page 14. They are talking once again about reasonable attorney's fees, reasonable third-party collection cost. Now, 209.0064 on page 15. This is where you send out a notice and you're telling people you're delinquent. Make sure you specify each delinquent amount. Don't just say you owe $1,000. Break that down. Say about how much is assessment, how much is interest, how much is cost. You now have to give them 45 days to respond, not 30 days anymore. So change your demand letters to 45 days from 30 days. And they can respond by saying, I'm going to pay in full or I'm going to do a payment plan. Be sure and give them that option for a payment plan. In 209.0065, that's credit reporting services. And that's if anybody's disputing what they owe, you can't turn them over to a credit reporting company. They have to have been given the right to enter into a payment plan, and you cannot charge a fee to the property owner for the reporting. For reporting it to a credit reporting company. Yes. All right, 209.007 on page 16, the hearing before the board. If the owner is entitled to a hearing to cure a violation, then they have the right to be heard before a board. They don't have to go to a committee and be heard before a committee. They have the right to go to the board directly and talk about their particular situation. You do not have to give them a hearing if it's a situation where you're going for a TRO or a temporary injunction. A TRO is, let's say you go home today, you see somebody starting to plow up the yard and they're going to turn it into concrete. You don't have to do the hearing. You don't have to call them and say, hey, what are you doing? Contact your attorney. Your attorney can send them a letter to stop, and you can have a lawsuit filed by Tuesday to stop them from doing what they're doing. So you don't have to go through the hearing when you have an emergency situation and somebody is doing something in violation of the restrictions. Okay, go to page 17. This is a whole new section they've added on this. So not later than 10 days before you hold a hearing, you've got to send the homeowner copies of the documents, photographs, and communications that you're going to use at that hearing. So if you're going to basically at the hearing show them, we sent you these notices, here's pictures of the violation, here's where we've talked to you by email or text, you've got to send that to them at least 10 days before the hearing. If you don't, if you send it 8 days before the hearing, they got a 15-day postponement automatically by statute. During the hearing, usually at hearings, a lot of times boards will just sit there and say, okay, tell us what your situation is, and they don't say anything. Now they say the board shall, or their representative, present the board's evidence to the homeowner. Then the homeowner or their representative has the right to present their information. If the homeowner shows up with an attorney and you did not know ahead of time, what you need to do is you need to say, wait a minute, we have an attorney, we didn't know you were coming, we don't want to talk in front of you without our attorney here, so we need to delay this hearing. Don't proceed with the hearing if their attorney's there and your attorney is not present. That is not wise. Okay? 209.015. This basically is an old statute. They made a little change to it, and essentially it talks about if you have a contiguous lot and somebody buys it. So let's say somebody buys the lot that's right next to them, or a corner lot, they buy the side property line or a back property line. They can use that for residential purposes. They can put a garage on it, they can put a pool on it, they can fence it in, whatever they want to do, as long as it's for residential purposes. And if they sell that, if they're going to sell their home, they've got to sell that lot with it. If they're not gonna sell the lot with it, they gotta take down everything that they put on that lot and sell it as an empty lot so it can be sold for residential purposes so somebody could build a home there. Okay? The last thing we'll cover is 209.016. If somebody's gonna lease their home, we don't have the right to interfere in the process. We can't ask for credit reports. We can't ask for a copy of the lease. We cannot ask them for background search of that individual. What we can do after it's leased, we can say, give us the contact information of the tenant, who they are, emails, everything, because they're probably going to be using the pool or something like that. And we can ask for the commencement date and term of the lease. But we can't get into the leasing process. And the final area is justice court jurisdiction. They're basically saying if you're an owner of the property, you can bring suit in the justice court in any county where that property is located. Okay, yes, sir. And that concludes this part, but we'll stay for some question and answer.
This is on the dot 016 on leasing. If your association has a leasing policy that states that the new owner, the leasing has to acknowledge the ACC document, can you have them sign that document?
Have the owner sign, like some of them will say to the owners, make sure your tenants are aware of the deed restrictions and stuff.
The owner is aware of the
Yes.
ACC and the new tenant is aware of that.
Yes, you can have the owner sign something like that, because you're not asking for information that's in violation of this. Yes, sir.
You haven't, didn't touch on towing, any new rules or regulations of having large code in your subdivision?
Well, what you need to do is look at your restrictions with regard to towing and what type of neighborhood you are, because that makes a big difference with regard to towing. Then if you are allowed to tow in your subdivision, say you're a gated community, make sure you have a towing policy. And I would have, more than anything, a towing policy so you give people notice, something's put on their car window, items like that. Make sure you're covered with that. Don't just tow out of the blue. Have a towing policy. And if you get in touch with me, I have associations who have them. We've set them up for them. I can work with you on that. Okay? Let me get her, sir, and I'll get you.
Question about fees from the property manager. So if you have a contract with your property manager that does not include late fees as far as your assessment fees, if they're put on a payment plan, but that's not within your contract, but the property manager wants to assess a late fee to the residents, is that within the law?
Well, are you saying they're not like in your deed restrictions? It doesn't say late fees? Because a lot of times the restrictions, when it talks about assessments, it'll say interest or late fees or cost and attorney's fees all become part of the lien.
No, we have a contract with our property manager, but we did not say that we wanted to assess late fees or installments on assessment fees.
Well, you need to talk to your management company on what y'all want to charge.
Okay.
All righty? Yes, ma'am. Yeah, let me get this gentleman. I told him I would.
My question is, how do you handle matters where you have a common area, such as a pool, where you have a community building and you have maybe a dog walk? It's all common areas within the confines of your association. And you have the new law coming out for the open carry weapon. How do you handle that matter?
You can put up signs, sir, with regard to not being able to carry a weapon like in the pool area or the dog park area. Contact me. I've had associations where there's companies who can prepare the signs for you. We can limit people on where they bring those items into. So contact me and I'll help you with that. All righty? Yes,
My
ma'am.
last question is about HOAs hosting meetings via Zoom for election of officers. If it's not recorded and you want to know who attended the meeting, where can you go back and review it? What is the state law on that?
There is none. That's all brand new with COVID. I mean, there should be some minutes or something showing that, I mean, most of them have people put down in the chat who's here, and they try to keep a record of that. But if they've had the open board meeting and nobody attended, then they don't, if people choose not to attend, they choose not to attend. But as long as they can show they had the open board meeting, gave the notice, the proper notice, and then did it, then they complied.
But you can't elect officers if you don't have a certain percentage present, right?
No, you have the election of, well, if your bylaws state you've got to have a quorum to do that, but usually the election of officers are done at a board meeting.
That's correct.
And that doesn't qualify with you need a quorum of members to be there.
I have a question. I haven't heard you mention who's the person that's over the management company?
The board?
No, there's a company that they are actually leasing from, the management company that's over the board. But there's someone that's above who owns the management company. The owners of the management company. It's
Right.
not our it's not the management.
Then so the management company's is a subsidiary of a bigger company, is what you're saying?
Correct. And we've been asking who that is.
Well, if they won't answer you, go get another management company. Go get one where they're open and obvious.
You know, the owners I'm talking about, the owners of the management company.
Right.
Owners. That's what we're asking.
If they won't answer that, go get another management company that's open and obvious of who owns them and everything else. They shouldn't hide that, but if they are, go get a new management company.
My question is, who is in charge of setting your assessment fees or your maintenance fees? That's paid, by the homeowner?
Look at your declarations. They will say how much they can be increased or not increased. Your declarations basically put the parameter on how much they can increase them.
But my question is, what if the management company is charging you like a monthly fee when it's usually a yearly fee?
If they're trying to collect an annual fee on a monthly basis and penalizing you for that, they've got to follow the documents too.
Okay.
Okay?
Can you touch briefly on the last one, section 209-07, the Justice Court? Can you?
Yeah, that means that you can, if there's a violation, like for instance, the $5,000, if you didn't comply with the management certificate and everything, or providing the documents, that can be filed in justice court, is what they're saying.
Okay.
Yes. And if you haven't provided documents to somebody, there's another area of the property code to say you file it in justice court.
To be sued.
Yes, ma'am. Yes, ma'am. Yes, sir.
What if you have a subdivision that's broken off from the rest of the subdivision because there's a bridge that's no longer there and we can't get equal access to our amenities?
Y'all are still a part of it. I mean, I understand the bridge not being there. Well, nobody will replace the bridge?
No. They say first it's the subdivision issue. The city says it's not their issue. The county says it's not their issue. It's over Harris County flood control property. There's 125 residents in my section that can't easily get to their amenities, and we're
Right.
still expecting them to pay dues.
Well, give me a call. You're still a part of that association. Give me a call and let's...
I did 2 years ago and never got a return call back.
Okay, well, if it's, I know which subdivision you're probably talking about, but you're still a part of that subdivision.
I'll call you again.
Okay.
All right, everybody. Did y'all enjoy listening to Miss Susie Rice?
Thank y'all for coming.